Good morning, Ms. McCarthy.
Good morning, Your Honor. May it please the Court. Kathleen McCarthy for the appellant Stephen Burgess. On May 1st of 2000, Stephen Burgess went into a Plymouth police station, trembling and shaking, indicating that there had been a fight at his home at 31 Sanderson Drive and that he believed he had stabbed his father. The Commonwealth proceeded against the defendant on deliberate premeditation and extreme atrocity and cruelty. I would suggest to you that one manner that they took in order to prove these theories was they improperly introduced two statements of the defendant that was in violation of Crawford.
Well, had Crawford been rendered at that point in time?
It had not. This trial took place in 2003, and Crawford
So
was issued in
is
2004.
Crawford retroactive?
I don't think that's clear, Your Honor. However, I would say that in view of how it has developed, that the defendant is here before you making a claim for a substantial risk of a miscarriage of justice, since there was no specific objection based on a confrontational ground, but there was an objection as far as one of the statements on, I would say, local laws. In other words, there were two statements and two prior bad acts that the Commonwealth intended to introduce. Trial counsel, the defense attorney at trial, withdrew his objection to one of those statements. But at trial, he did, in fact, make an objection to the second statement, which I'll get into, on the grounds that it was not a spontaneous utterance and it was not state of mind and it should not come in. So although the objection to the second statement, which would have been the February 23rd statement, was made, it was not made on a confrontational ground. However, there was an objection to that information coming in at the trial, but not specifically on confrontational grounds. So what was introduced, and I would suggest it's in clear violation of Crawford, and in fact the Commonwealth did not argue otherwise in its brief, was a statement from February 10th, which was about 3 months before the incident that we are discussing today. There was a radio call for the police to go to this home, that when the police arrived, the decedent stated that he was having problems with his son, Stephen, and that he believed that his son should get some type of medical attention. He also indicated that he wasn't okay, meaning the decedent was not okay, and that his son was not okay. Following that incident, and I would suggest to you the more troubling statement, is a result of a radio call to the home on February 23rd of 2000. When the police arrived at the home on that date, the police arrived, the incident was obviously over, and there was a conversation. The decedent described to the police that there had been an argument, that the pair was arguing over the fact that the defendant again needed counseling and that he wanted him out of the home. According to the decedent, the defendant then threatened to kill the decedent. He said, "I'll kill you." And the decedent then told him to leave. The defendant said, "I'll leave and I'll come back with a gun and I'll shoot you." That whole statement was introduced. Beyond that, and I would suggest to you even more troubling, is the statement by the decedent that he believed that the defendant was actually capable of coming back and carrying out that threat. Clearly, that statement was made in violation of Crawford. Now, as far as whether that affected the trial, whether it created a substantial risk, harmless error, whatever standard you apply in this case, I would suggest to you that statement was a significant part of the Commonwealth's case. The Commonwealth relied on that statement in its opening.
What was the basis that the judge relied on to allow the statement in?
It would be the second statement because, again, for some reason, the first statement was withdrawn, the objection to. I believe it was on state of mind of the declarant, which was, I suggest, a little bit complicated because when you're talking about the declarant, which is Mr. Burgess, stating that the defendant said, I'm going to kill you or I'm going to come back and kill you, and then him saying that he believes that the defendant has the capacity to do it, what you're talking about really is the state of mind of the defendant, not the state of mind of the victim, which I suggest to you would be the reason that it would come in. So I would suggest that the reasoning, even under the local rules, that the judge allowed it in was improper. Another reason he gave was that it was a spontaneous utterance. However, I suggest to you that that would be inappropriate to apply to the facts in this case, because it did appear that by the time the police arrived, the incident itself was over, and the officer was simply questioning the parties about what happened. The defendant was not in the area, I suggest to, as the questioning, did not try to interfere with the questioning, but was basically just there. Now, as far as what effect that statement had on the trial, again, looking at it from the perspective of a trial attorney in the Commonwealth, when they have a piece of evidence, what do they do to try to get it in? They file a motion in limine. And that's what they did in this case, because in their mind, it was important evidence. Now, when I finish, I'm sure they're going to stand up and try to explain how it really wasn't that important. But ask yourself, if it wasn't that important, why did they work so hard to get it in?
So we always look at the trial at the end, though, to find out what the evidence actually was that was produced at trial. Was there other testimony that the defendant had threatened to kill his father? Testimony from others?
I would suggest to you not quite in the fashion and as strong as it came in from Mr. Burgess, but that also dovetails into my argument that there were basically 3 witnesses that the Commonwealth comments on in its brief.
But it's going to be important to me that I actually know the answer to that question. I know that you've got the defendant's sister, his former, and I'm using quotations, girlfriend, and the victim's friend, Ms. Fox.
Yes.
Did any of those people testify that the defendant said that he was going to kill his father?
Not that he was going to kill.
He would kill, that he wished he could kill?
Yes, that was in Meredith Porter, but I would like, if I could, I'll take that one at a time right now. Kelly Burgess, her testimony on direct, I would suggest quite strong for the Commonwealth, saying, I lived with my father, my brother, their relationship deteriorated over time, they had arguments, they had fights, and whatnot. On cross-examination, the defense attorney came up and did a good cross, I would suggest to you, and took the sting out of that testimony by indicating, well, Ms. Burgess, in fact, you weren't home all the time that your brother and father were together, were you? No. In fact, what you're testifying to is basically what your father told you, the arguments and whatnot. Isn't that true? Yes. And in fact, Ms. Burgess, isn't it true that there's some type of sibling rivalry? Yes. What that indicates is how important cross-examination is. You have it very strong on direct, which is often the case, but after cross-examination, the sting has been taken away to a certain extent of Kelly's statement. Continues on with...
But the testimony is still in evidence. It's still relevant.
Yes.
It doesn't violate Crawford, that other testimony.
That testimony doesn't, but I would suggest to you that it underscores how important the right to cross-examination is, because basically all you have with the decedents, with the statements from the decedent, you don't have an opportunity to cross-examine. You can't take the sting out of that testimony because nobody else was there to hear it. This isn't a situation where the defendant's statement was made to another party that's still around, that you can cross-examine and you can kind of take the sting away. In this case,
it's not clear to me
it was not there.
It's not clear to me from your recitation of the facts, and wasn't really clear from either briefs, whether after all of this, the sister is saying, I heard the defendant say that he wanted to kill my father.
And you're not clear that that was...
Whether she said, I heard the defendant say.
I don't think that was clear after... I don't think that was anything she specifically said, Kelly Burgess.
The Commonwealth attempt to get up and say, did you actually hear the defendant saying that?
I unfortunately don't recall that, but I don't believe so, Judge. I'm not quite sure on that point. Okay. Christine Fox, however, is the second witness, and again, the Commonwealth points to that. Look, it's cumulative because Christine Fox, who was the decedent's girlfriend at the time, had a conversation with Mr. Burgess, and Mr. Burgess said, I hate my father, and they had that type of conversation. Very damaging on direct.
May I?
Sure.
There was more to it than just, I hate my father, wasn't there?
With Christine Fox, that they were having problems and that I hate my father. Meredith Porter, who is
And I'm going to get him?
that, I believe that was Meredith Porter
Okay.
who testified to that. So there are 3 witnesses that they're saying are allegedly cumulative. Christine Fox, my understanding was that there was a party at St. Patrick's Day in March. She had a conversation with the defendant after the party, and the defendant was indicating how much he didn't like his father and he hated him. That was the direct testimony. On cross-examination, it comes out, well, this conversation took place in March, a few months before this incident, yes. She was interviewed in May 2nd, May 3rd, right after the incident, and it never occurred to her to tell the police about this statement, which I suggest to you is obviously helpful to the Commonwealth case. She does not recall the statement or even tell anybody about it until 3 years later, right before trial. What does that do? Certainly doesn't erase the testimony, but under cross-examination, what it does is it takes the sting away, which is why the right to cross-examine a witness is so important.
Ms. McCarthy, the Commonwealth raises an interesting argument, and the Commonwealth concedes as it must that Crawford applies, because this is a direct appeal, but that we have case law that suggests that the wrongdoing of the defendant, and therefore making, because a witness is unavailable because of the wrongdoing of a defendant, he can't rely on certain protections. Do you know of any case which has addressed that issue in the wake of Crawford?
Not in the wake of Crawford, and I am glad you brought that case up, because that is basically the rule of forfeiture by wrongdoing, and that case is in the context of when someone has been charged, the case has been indicted, and the defendant is somehow directly or indirectly trying to intimidate witnesses not to testify. In that particular context, clearly there's some type of public policy I would suggest to you that the court is addressing and why that shouldn't be done.
Do you know of any cases in the wake of Crawford where the witness has been unavailable because the witness has been killed?
Killed by the defendant, Judge, or just killed in general?
Killed by the defendant.
No, I haven't, and I will look into that again, but I haven't come across a case on that. But as far as the direction that would go in, I would suggest to you that if you did apply the rule of forfeiture by wrongdoing to homicide cases, you're basically opening up Pandora's box
Well, would there be a distinction between the fact that the forfeiture by wrongdoing is adopted in the Edwards case, was the wrongdoing, the witness was made unavailable by the defendant, allegedly, after the indictment?
Yes,
Here,
exactly.
the witness is made unavailable by the defendant before the indictment.
Exactly.
That's probably a key difference.
That's what I was trying to articulate, apparently not very well, but that is the key. And if you took that and applied it to homicide cases where a defendant kills a victim, you're opening up Pandora's box to violations of Crawford, which frankly has taken
Why?
a long time to get back.
Why?
Because obviously the decedent would be gone and you could not
But
do a
how many times
cross-examination.
do we have statements by the decedent about the defendant?
How many times?
Yeah.
Well, I would suggest to you by the decedent, if you look at the Qualls and the McGraw case, which are in my brief, in those particular cases, there were statements by the decedent about the defendant. Those were statements about fear that the victims had about the defendant. And in those cases, the court came down on the side, and particularly that in those cases it was similar to this case in that not only am I afraid of the defendant, but he's back in town, I'm afraid he's going to kill me, or if something happens to me, then it could be the defendant.
It would also come up presumably in domestic violence type cases where the victim has said to people, I'm afraid of the defendant.
Yes.
He's threatened to do this or that.
And the courts have found, I would suggest to you, and they've been careful not to allow those statements, is because if a decedent is afraid of a defendant and says, I think he's going to kill me or she's going to kill me, and then lo and behold, that individual turns up deceased, it's going to be hard for the defendant to get around the fact that, geez, the victim was afraid of him and thought he was going to kill me or she was going to kill me, so therefore he did.
I'm really thinking not so much of that statement, but a statement by a deceased person telling another, I just got a call from Kenny Janie, whatever it is, and he has said he is going to kill me. Not, I'm afraid.
That is more a direct threat, and that is also to another person that would be available to testify in court, and you could cross-examine. In this case...
No, you've just said we can't.
Well,
You've just said if the...
I'm sorry, I think I misunderstood your hypothetical.
Well, if in this case, if the sister who is still alive testifies that her father told her that the defendant, so the sister didn't hear the defendant say this.
Okay.
The sister says, my father told me that my brother said to my father, I am going to kill you.
I would say that should not come in. That's not only hearsay, it's basically totem pole hearsay, and you're clearly denied the opportunity to cross-examine the source of that statement.
But you can cross-examine the sister. You can ask the sister, what were the circumstances? Are you sure those were the words he used? I mean, so it's, I understand there's a problem, but if the father is no longer available, I mean, you're essentially attacking it on Crawford grounds.
Yes. And I would suggest to you that would be inappropriate, because I think that, again, you're totem pole here saying it, and that I would suggest to you, so you don't only really have one area that you're trying to get over. It's kind of two steps. The decedent said it to the daughter, and the daughter said it to someone else. I mean, you're getting so far.
Well, then let's make it a little easier. You've got a recording of the deceased person saying, my son is here and he is threatening to kill me.
I think that would be closer to a Crawford type situation, perhaps similar to doing a Crawford analysis, whether it was reported, whether it was testimonial, non-testimonial, and whether he's available, and you go through that analysis and reach a conclusion as to whether it's admissible under Crawford or not.
No, but I'm asking you whether in those circumstances, if the witness is not available, if it doesn't meet the Crawford standard, in other words, if it, he's calling a friend afterwards and saying, my son's just been over here and has threatened to kill me, what do you think I should do? I mean, in other words, it's not testimonial and so on and so forth. Then the question is, if the defendant has made the witness unavailable by killing him, should the Commonwealth be able to use that statement?
I would suggest no, because of the obvious confrontational issues. And also, distinguishing it from Edwards, I mean, that's not a case where there is actually a case pending, where the defendant is out there trying to intimidate witnesses not to come in, which I think is a different situation.
But he could kill a witness. A defendant could have committed a murder. Somebody saw him commit the murder, and before he's even indicted for the murder, he kills the other witness because he doesn't want the person to testify. But in the meantime, that witness says, he called me and told me he's going to kill me because I witnessed him commit a murder.
I think that's
There's been no indictments in that circumstance.
I think that's a different case, because, I mean, you're talking about getting rid of witnesses, and here the victim is the witness, so to speak, and it's a different.
Well,
the difference is not only there's now been an indictment, or there wasn't an indictment, but that the defendant's conduct was not with the intent to make the witness unavailable, whereas in Justice Spina's case, it would have been with the intent to make the witness unavailable, and that's sort of one of the three key Edwards factors.
Yes, so that, true, obviously it appears that the motive in this case, as indicated by the Commonwealth, is different. So I think it would be a dangerous place to go, because you're obviously just opening up a simple line of cases that would only occur in homicide cases, where I would suggest to you the right to cross-examination should clearly be scrupulously protected. Moving on to Meredith Porter and how important cross-examination is. On her direct examination, she indicated that defendant Stephen Burgess said that he had it in for his father, that he was going to kill him, and hated him because they were having a discussion and disagreement. Again, very damning. On cross-examination, the defense attorney got up and said, well, wait a minute, that wasn't the whole conversation, was it? No, it wasn't. In fact, later on, about 15 minutes later, the defendant said that he didn't mean it and he was only kidding. He was just upset when he said it. What that indicates to me, Your Honors, is that it heightens the importance of cross-examination. And in this particular case, it was a crucial piece of evidence, an important piece of evidence that was used by the Commonwealth to secure a conviction. If you look at my brief on page 28.
Thank you, Ms. McCarthy. Your time is up.
Thank you, Your Honors.
Good morning, Mr. Bender.
Good morning, Your Honors. May it please the Court, I am Robert Bender. I am appearing as a Special Assistant District Attorney for Plymouth County, but I work for Middlesex District Attorney's Office. I apologize if my voice isn't clear, but I hope that you can hear me, and I gather that you can.
What about this statement? I mean, at least as I read this, an awful lot of what happened on February 10th and February 23rd. These are the two incidents where the police came out to the home because there was a problem, right? I take it much of that would be admissible under any sequence. I mean, the police came, they could testify to what they observed.
Yes.
Right? With respect to February 10th, what the victim was asking was that the defendant be medically evacuated because of an obvious crisis problem, right? Probably admissible.
And as to February 10th, the defendant specifically said at the end of the voir dire that he had no objection to that testimony coming in.
So February...
It fit his case, he said.
So
This is all before Crawford, so we have to kind of look back at to what...
No, I understand, but as my sister indicated, the statements that that Officer Borelli, who was the witness to the February 10th statements, his statements as to what happened were not any. They didn't contain the threats and the language that we're talking about from the second occasion.
So it's February 23rd, and again, a lot about February 23rd could come in as well. Of course, the police come, they're screaming or shouting inside the house. There's obviously an argument going on. People are very shaken. And I take it after that, the victim got a restraining order.
Yes, that day.
So a lot of that comes in to sort of demonstrate the relationship leading up to this murder. I mean, a lot of it's admissible, but let's focus down on that sort of one statement in which the victim says that the defendant threatened to kill him, and I can't remember what it was precisely, but threatened to kill him and that he believed he would come back, he would kill him, whatever those words were. Why isn't that in the context of this case? Why doesn't that present a substantial risk or substantial likelihood of a miscarriage of justice?
Well, it doesn't because it is cumulative. Now, granted, it comes from the victim's. It's cumulative because of what the other witnesses that we discussed or the court discussed with defense counsel.
Is there other admissible testimony?
There is other admissible testimony
Not
that was
it admitted, admissible post-Crawford, where there's testimony that the defendant said, words in effect, I intend to kill my father. I don't mean whether you could draw an inference.
I'm not quite sure I understand the court's question. The defendant's, in this case, the defendant said to his ex-girlfriend, Meredith Porter, I hate my father, I'm going to get him. And that is the same threat that we have here. It's not at the same time.
Well, I'm not sure that I hate my father and I'm going to get him necessarily means I'm going to kill my father.
Necessarily, no. It necessarily isn't the issue. It's you have this direct testimony on the same relevant issue.
Mr. Bender, you have just said that the testimony to which Justice Cordy directed his question, the specific language of the victim, you said was cumulative. And I'm just trying to find out, of what is it cumulative?
It's cumulative as to the defendant's state of mind that he is developing from January when he comes back from the Mass Maritime and resumes living with his father, that in February and in March...
It may be cumulative that he has a hostile relationship with his father, But we've got a conviction here. Wasn't one of the grounds premeditation?
It is on the grounds of premeditation.
Yes. So I'm asking you, what is the other evidence? You have said it's no problem, assuming we can get it in, assuming it shouldn't have come in because it won't give rise to a substantial likelihood because it's cumulative. And I'm asking you, what other evidence is there that the defendant said, I will kill my father?
The most specific is what Meredith Porter says. He says, I hate him.
That's not
in
exactly.
anger. I hate him angrily. She said, I'd never seen him in the 5 years I knew him so angry about this. And he says, I'm going to get him.
Okay.
And that is, in the Commonwealth's opinion, substantially the same as what the deceased, the victim, reported to the police on February 23rd when they came to the door and found him visibly upset, shaking physically, and reports this is what happened.
Was there any forensic evidence linking the defendant to the crime?
In the forensic evidence linking to the defendant to the crime?
And to confess.
Well, in addition to his saying that he did it, we find there's no DNA. There's not DNA in the sense that evidence of him himself is linked to the crime, but the things that he said to the police, that he got in the car and he drove the truck and he drove down to the station, and that he did it. He had blood on him, on the clothing. He came to the police
Fingerprints
department.
on the knife. The
He
fingerprints
had
are on the
fingerprints
knife.
on the knife.
There's no there was a homicide, and there appears to be no question based on the defendant's confession, which was, once you get past the, isn't there voluntary in this issue? This is non-Mirandized, right? So, but assuming you get over that, this man is no longer alive because of the actions of the defendant, correct?
Correct.
The question is it murder in the first degree?
Well, under the 33E question, it's murder in the first degree, yes. It was the jury found on two grounds, the two that were presented. One, that it was an extreme atrocity and cruelty basis, and the second, that it was done with deliberate premeditation. The deliberate premeditation theory, this gets back into why the Commonwealth, or how the Commonwealth went into explaining the process, I call it the process of the murder itself, and that it gave the defendant an opportunity to show his premeditation, that he not only acted to kill, but that he wanted to kill his father, that he thought it and decided to do it. This starts with the story that the testimony that first there was this, what they call the punctate wound, the knife tip through the shirt near the navel of the victim that left a mark there. That this is, as the two of them are standing face to face, this is done. And it was something that there was much cross-examination about to determine that the opportunity to do that wound had to precede the two deep stabbing wounds that came around and under the arm and to the side, one above the abdomen going down, and the second one lower and into the intestines, both being fatal within 5 to 10 minutes, if not immediately treated. Those two wounds followed this first wound, and they also were physically imposed in a way that showed that the victim had turned away, and that the assailant, his son, had grabbed him around the top, causing a lot of damage and tearing to his sweatshirt, and inflicted these two wounds. And at that point, he was released, and the man was able to stagger and carry, bleeding, putting his blood all through the hallway and into his bathroom, where he was able to take himself away from his assailant. And the indication then was the testimony in the bathroom becomes important too. That the forensic observations were that the victim stood against the inside of the bathroom door, that he had opened the door and closed the door and was leaning against the door. But for some reason, he didn't die there by the door from loss of blood, but he moved himself away from the door. What made him move away from the door, the jurors can ask, or the court can ask. Well, we know that the defendant went into the bathroom because the murder weapon with his fingerprints was found in the bathroom on the vanity of the sink. And the victim was found without further wounds or evidence of any struggle there, but just evidence that he was there in that bathroom going from different directions, not just behind the door, but to the very back by the toilet, and then into the tub itself, his blood flowing from him. What made him move away from that door is the question that was being asked, and the inference was his assailant made him move away from that door, that he wanted to make sure that his father died. This went to the extreme atrocity and also goes to the premeditation of first the confronting his father, putting the wound in his belly, the punctate wound, and then viciously attacking him as the father tried to withdraw. This is premeditation. It's not something that takes the months to contemplate. But in this case, we have evidence of what was going on in the months before. Yes?
What that sounds to me like is, even if we were to disregard, in other words, if we were to conclude that the statement that the father made was improperly admitted, that there is substantial other evidence, not cumulative evidence, but other evidence of premeditation.
I cannot disagree.
No, I'm
The thing is this case wasn't based on the evidence of premeditation is that he threatened his father in February. That's not why we're saying.
Surely the argument was made in closing. I'm sure the assistant district attorney didn't ignore the fact that he put in evidence that.
No, I'm confident that that these statements came into the closing argument, but not to say that on February 23rd he made the decision that was acted on April 30th. In a general way, yes, but not in the. I finally had an opportunity to carry home this threat that I made, and that he was thinking of what he did on February 23rd when he murdered his father on April 30th or May 1st.
Well, all you need for premeditation is a matter of seconds, so you don't need anything from that far back.
That's why I'm saying that statement didn't go to the premeditation directly. The act itself showed its premeditation. So in that sense, it's dramatic as far as the relationship, but this crime is dramatic enough where you have a murder between relatives. There is drama, tension, and the sort, and you want to know what is going on that would cause a son to take a knife and do this to his father that night. So that is really in the context of things, and this is also, I think, why the defense attorney said as to the earlier statement from the earlier police officer on February 10th that he had no problem with that coming on because it helped his case to show that there was this concern, this sort of what the relationship was. He wanted that to come in.
There was a self-defense instruction, but
Yes.
but there was not a voluntary manslaughter instruction by reason of provocation or heat of passion.
Yes, and the defendant claims that reasonable provocation instruction should have been given in his case.
And why shouldn't it have been given?
It shouldn't have been given because we don't know that that's what happened. The defendant would ask the jury to speculate that he was provoked by the only things he told the police that happened before the stabbing, and that's that he and his father were arguing. He told them the content of the argument was about his mother, according to the defendant. It was his mother's birthday that night. And the defendant said that he told his father how much he thought he had harmed his mother emotionally or whatever. The divorce was about 9 years before. And he said specifically, the defendant, that I told him you hurt my mother. And the defendant says that his father responded, I'll hurt you. And then the defendant says it became a physical thing. There was some testimony about what exactly he said, but the defendant only said as far as the physical thing, other than he stabbing his father, was that his father shoved him. He said to the photographer witness, there was a photographer at the booking desk that took a lot of pictures of the defendant's body, because the defendant said his father actually shoved him into the refrigerator. Of course, there was no evidence that there was anything disrupted on the refrigerator.
I know, but
that's the extent of the evidence of provocation that we were arguing. My father said, I'll get you, and my father shoved me. He didn't say that he fell. He didn't show any. There was no evidence otherwise that he was injured in any manner whatsoever. And on the basis of this alone, the defendant says that shows that not only was there reasonable provocation under the law, but he himself was provoked and no longer could, he had formed this heat of passion here to do something. This is not the same conditions or requirements as self-defense.
I was going to say, how did he get a self-defense instruction?
Because we are to really look at evidence in the light most favorable to the defendant's point of view here, and where the defendant, I think, wasn't looking for a self-defense instruction that I'm not guilty, but just that my response to the attack that my father made to me was excessive. If my father shoved me in the course of a heated argument, all I did was defend myself. Well, I went further than defend myself. I used excessive force to defend myself.
Got more than he was entitled to on that.
I believe so. But these are the types of decisions where some feel that it's better to give an instruction that you don't need than not to give an instruction that you do need.
Were you trial counsel, Mr. Bender?
No, Your Honor. But this is the type of things that come up, and as the Court has seen, there often are cases where a larger part of the argument is what instructions are required or should be given and what the tactics might be on it. But here there wasn't, I think, the best case, as I cite on that, is the Commonwealth versus Masello, I think, where it says some physical contact, like you have a father, if the father shoved him, as the defendant says he did, that didn't give rise to the kind of provocation, heat of passion response that our statutes, our cases call for, and saying that this is manslaughter, not a killing with malice.
The statement, again, going back to February 23rd, I'm sorry to jump around a little bit, but the portion of the statement that came in that the victim here, the father, said, "I believed the threat. I believed he would do this."
Well, I'm in fear. He was.
Is that the actual wording? I don't have it in
Well, I think what I put in my brief is the actual wording.
Let me see that.
I'm trying to turn to that language myself. The father said that the defendant clenched his fist, advanced on him, and said he was going to kill him, and that he would come back with a gun and shoot him dead. And the father said, I was afraid of that and fearful of that. And you have then the victim father's close friend, Kristen Fox, says that thereafter, when the restraining order went out, the defendant was out of the home for a few weeks until just before St. Patrick's Day. The modification of the order allowed the defendant to move back in as long as he didn't commit abuse. Simultaneous with that, the defendant started the counseling that the father had asked him to get, and the father moved the weapons, the firearms, out of the house to his business.
But focusing in on those critical statements on February 23rd, what do you say the basis was to get in the statement that I believed, whatever the statement is, and I don't have it in front of me, not only that he said he would kill me, but also that he believed that the defendant was capable of doing that. Am I misquoting here? I don't know. I'll assume, for the sake of the question, that is what it is, and the reason what it is what's the basis of that?
In assessing a threat that's being made, the hearer or the person being threatened's belief is a factor in how serious that threat is or what should be taken. This wasn't just a case of the son saying something angry to his father that the father wasn't well, he was concerned that the son was so upset, but that he wasn't concerned about that his life was at risk. The hearer saying that I was concerned that my life was at risk. This case was tried also that this was a violation of the restraining order that issued out of this incident. I think it's part of that to show that the defendant's state of mind towards his father was so serious as to actually frighten the father, and that the father will be able to say that.
And you say that the statement that he made to his girlfriend, "I hate my father and I'm going to get him," is cumulative of what the father was statement was to the police.
It's other evidence on the same, of the same kind.
I'm going to get him.
You say angrily, I hate my father, I'm going to get him. It's not as, it's not as specific as what the father said. I have no quarrel with that. But the meaning of it and the passion behind it is what was being said. That a month after the incident, the police officer reports this, intermediate between the time of the police officer report, then you have the statement to his girlfriend, and then you have the murder itself. We're almost talking in equal parts time as we move from January to February to March to April 30th, the night of the murder. I regret I didn't have time to answer the court's questions on the Edwards issue, but I cited cases in my brief that are specific involving murders of the victim, where they are post-Crawford, because these cases are in 2007 discussing, in light of Crawford and what Crawford and Davis to say, how would we apply this forfeiture by wrongdoing? And I specify that the problem that these courts are having is the meaning of with the intent to make the witness unavailable. That where does that come from and how important that is? But I would trust the court will be able to read those cases and see where the Commonwealth is coming from.
Thank you,
Thank
Mr.
you.
Bender.